I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute, and we are coming to you from ABI's annual spring meeting in Washington, D.C., where, just yesterday, the ABI Commission on Consumer Bankruptcy Law issued its report recommending changes that Congress ought to make in consumer bankruptcy law. To discuss that topic, we will be speaking for the next few minutes with retired bankruptcy judge William Brown, who sat 20 years in Nashville, Tennessee as a bankruptcy judge. Judge Brown, of course, served a term on the Ninth Circuit Bankruptcy Appellate Panel, and he continues to this day to be a very prolific writer about everything bankrupt. Judge Brown, thank you very much for spending more time with us here now on top of the hundreds of hours that you spent and devoted to the Commission report on consumer bankruptcy law, because I believe that report is going to be just infinitely important for the lives of millions of Americans, and we thank you. Judge, let's begin with most difficult question I can think of, and that is, in your judgment, what is the most important of the recommendations that the Commission made with regard to consumer bankruptcy law?
Thank you. There are 48 different discrete topics addressed in the report, but I would have to say, because of the amount of publicity generally today about student loans, that our recommendations on student loans would probably be the most important. They run the range of recommendations that Congress should go back to allowing student loans to be dischargeable after they are 7 years old, basically.
Well, let me ask you this, Judge. Would it be fair to characterize the current state of the law, both statutory and decisional, that student loans are essentially non-dischargeable in bankruptcy?
That's essentially correct. The academic studies show that very few consumer debtors either A, can't afford to pay an attorney to tackle this problem, or they simply are not able to show that under the current standards that they have what's called an undue hardship.
Well, let me ask you this question. From your point of view, do you think Congress intended to make student loans virtually non-dischargeable?
I don't. I mean, I think there certainly is justification for, and the Commission recognizes this in its recommendations now, that there are justifications for treating student loans differently from like credit card debt, because they are largely government-insured loans, and that they should be repayable if the debtor is able to do it.
Well, let me ask you this. What is it that the Commission is recommending that Congress or the courts do with regard to dischargeability of student loans?
First, that we go back to allowing student loans to become dischargeable at some point in time, and our recommendation is 7 years is a good time period. In other words, if someone gets out of school, they've incurred student loan debt, and within 7 years of that loan becoming due, typically, by the way, student loans are repayable under contract for 10 years. But so let's assume 7 years after that loan first became due, the debtor either is ill, disabled, hasn't found work of any amount to justify or enable the debtor to repay that. There should be a recognition that at some point in time, they should simply become dischargeable debts. In the meantime, we keep the provision that current law, and that is that if the debtor can show an undue hardship prior to the 7 years, they could become dischargeable. But part of our recommendation also is that courts should not add on gloss to that undue hardship language. That's hard enough to show.
Well, you know, by the way, that's always struck me as really rather amusing when you use the phrase in the affirmative, not in the negative, because as courts are interpreting the law now, if you have student loans, you have to incur due hardship. So some kind of hardship isn't being inflicted by the courts and Congress
Absolutely.
on debtors. So,
and there's no definition in the code now of what does it mean undue hardship.
well, what in the Commission's view would be the proper definition?
We keep the idea that undue hardship can be justifiable, but make it a realistic showing. In other words, don't require the debtor to show that she is living at a poverty level, a reasonable standard of living.
Let me stop you right there, because my interpretation of decisional law these days is that virtually no one can discharge student loan debt unless the person is disabled. Typically, totally disabled.
Not only that, but also many opinions also interpret undue hardship to say that the debtor has to almost show that they are at a poverty level, that they simply are not able to live at all. And we shouldn't be requiring debtors to prove that they are living at poverty level. We should allow it to be a test of, is this debtor really able to repay? Is there any foreseeable outcome where the debtor might get a better job? We have decisions, for example, that say, well, this debtor could have gotten a better job, but there's absolutely no proof that the debtor was able to get a different job. It's just that the courts are making almost the debtor do the impossible.
Now, what is the standard that the Commission recommends with respect to the level of hardship that's too much?
Yeah, as I say, we try to encourage, or we do encourage, that the court should interpret the current law to say that all the debtor would have to prove is either because of illness, because of lack of employment, inability to get a job, whatever the circumstances are, that the debtor is living at a reasonable standard of living, and that the debtor has made a good faith effort to repay the loan. Now that simply may mean the debtor has tried, but simply unable to get a job sufficient to repay the debt.
Okay, well, listen, God willing, Congress will bite on that, because what it's doing right now, it's taking people with student debt out of the housing market.
Correct.
Because they
That's exactly right.
They cannot have a balance sheet that makes them eligible for a mortgage. Listen, let's move on to a different question. Also, I think a difficult question for you, Judge. That is, what was the most controversial issue that the Commission tackled? And when I say controversial, I don't mean controversial among the Commission members. I mean, what do you view is going to be most controversial when it hits the floor of Congress?
That's a very good question, because my view is that one of the more difficult questions now is, what does a debtor do if the debtor is not able to afford a home that the debtor's been living in as the residence, but the creditor doesn't want to take that property back, perhaps because there is a large amount of accrued homeowner association fees, or real property taxes, or maintenance issues. There are cases, for example, where property has been flooded, damaged, and yet the debtor can't give it back, so to speak.
And as background, and correct me if I'm wrong, but under present law in both chapters 7 and 13, even if a debtor walks away from a property and discharges personal liability on the mortgage, is it correct that that debtor remains liable for future homeowners association fees and also personal liability if, say, for instance, someone is injured on the property?
That's generally true, and that's a real problem. So these properties are sometimes called in the press zombie properties, and that is that the debtor simply can't get rid of it, yet the debtor is still liable for something like, as you mentioned, homeowner association fees.
So you don't get a fresh start.
You don't get a fresh start, and you're burdened with property forevermore, it seems like.
Exactly.
So our recommendations include, number one, that homeowner association fees should be dischargeable, assuming that the debtor is not going to continue to live in or rent or use the property. So if the debtor is trying to get rid of it and give it up, the homeowner fee should be dischargeable. And then the other thing we do that will have some controversy to it is that we make a proposal that in Chapter 13, the debtor ought to be able to say to the mortgage creditor, I'm no longer going to live in this property. It's not my principal residence. I'm trying to give it up. I'm giving you a chance, creditor, to take it back in satisfaction of the debt. And if you don't want to do that, then the property could be sold under a public sale where the mortgage creditor, of course, could bid on it, but at least give a way for the debtor to get the property back in the hands of the creditor.
Mm-hmm. Now what about, so that takes care of the problem for Chapter 13, but what about Chapter 7?
Well,
how could a debtor get rid of the future personal liability in 7?
In Chapter 7, of course, currently the debtor can walk away from a mortgage and discharge personal liability on the mortgage, but still, under current law, be liable for continuing homeowner fees. So, as I said, part of our recommendations are that those homeowner fees should be dischargeable if the debtor is not going to continue to live in the property or use it.
I see. So you got to make that election right up
Correct.
front in 7.
Correct.
I see. Well, listen, could you tick off for us quickly here a couple of other recommendations by the Commission that you believe are among the most important?
I think one, of course, related to Chapter 13 bankruptcy is that many people are not eligible to file Chapter 13 today because of the debt limits, because the debt limits are reasonably low, both in unsecured debt and secured debt. So if you have a large home mortgage, or if you have a large amount of student loan debt, you're not perhaps eligible to file Chapter 13. So the Commission...
And by the way, that's really silly, at least with regard to student loan debt, because student loans are not dischargeable.
They're not dischargeable anyway.
At least not under present law.
And so to keep someone out of Chapter 13 bankruptcy, and the whole idea of 13 is if the debtor's able to repay part of their debt, they would do so in a Chapter 13 plan. So our recommendation is to increase the debt limit significantly to $3 million. Oh. And that may sound like, well, that's a lot of money. Yet there are people that have house mortgages that are, hundreds of thousands of dollars, or have student loan debt that are hundreds of thousands of dollars.
If you're not eligible for 13, Chapter 11 is virtually impossible.
Correct.
For individuals, for consumers.
Expensive to do, much more expensive, and
virtually
much more difficult. For a debtor
well,
to do.
in addition to raising the debt limit, what else would be at the top of your list?
Other things that we do and recommend and relate to Chapter 13 are, for example, there should be a recognition that a debtor ought to be able to deduct from the current income, current monthly income that's used as part of the means test for bankruptcy, such things as disability benefits that are under the Veterans Administration. I mean, right now the law says that you don't include Social Security benefits in the means test, but you do include disability payments for veterans or for other government disability programs.
Right. Well, Judge, listen, we thank you very much for the huge time that you have spent working for the Commission. And I would note for our audience that these Commission reports are not an exercise in futility. What was it? 3 years ago now, I believe it was, the ABI Commission issued its report on changes in reorganization law for companies, small companies as well as individuals. And I'm pleased to report that as we sit here right now, bipartisan bills are pending in Congress, both the House and the Senate, to adopt some of those more important recommendations that the ABI Commission made. And methinks that the same will occur, and perhaps even quicker, because who votes for members of Congress and the Senate? It's people, many of whom in this country sadly will be bankrupt. Judge, thank you again very much for your time. Be well and use your energies going forward to push these ideas.
Thank you very much.
Thank you.